Welcome to this presentation on native title and the foundations of land title in Australia. My name's Kate Galloway. I'm Assistant Professor of Law at Bond University and an adjunct at James Cook University. My interest lies in land tenures and in particular the rights of Aboriginal and Torres Strait Islander Australians to land. Now in this presentation we're going to run through the evolution of native title according to Anglo-Australian law. So in broad terms what you'll see on the screen now is the general progression of the underlying concepts that justify Anglo-Australian law relating to land tenure. And the first of these of course is terra nullius, which as we'll see is an international law concept from the 17th, 18th centuries that justifies the English becoming the sovereign ruler over the continent of Australia. Now terra nullius was accompanied by a common law doctrine of desert and uncultivated, which justified the importation of English concepts of land law into Australia and effectively dispossessed the traditional owners here. And then finally what we'll see is this idea of land rights coming into existence or coming into fruition through the decision in Mabo and beyond. So in the bottom line here on the screen are more particular concepts that are represented by these doctrines or principles that you see in the top. So we see the concept of sovereignty, which is necessary to underpin the idea of land ownership in Australia. Reception of law, which is the importation of English law into Australia, and this was justified by the doctrine of desert and uncultivated. And the law that was received in Australia is the doctrine of tenure, and we'll see the implications of the doctrine of tenure in this presentation today. The decision in Mabo, the High Court decision, which fundamentally altered the basis on which we understand the operation of the doctrine of tenure in Australia, and that was followed of course by the enactment of the Native Title Act. So against this background, which is deliberately from the perspective of what I'm calling here the Anglo-Australian legal system, we can contrast the experience of Aboriginal and Torres Strait Islander Australians and what they know to be true. So the knowledge and experiences of traditional owners, which is that sovereignty has never been ceded, that the land itself has never been ceded, and that traditional law continues. So we have this fundamental tension between the perceptions of the Anglo-Australian legal system and the understanding and the truth, I guess, as it is known by Aboriginal and Torres Strait Islander Australians. So let's start with this idea of sovereignty and what we understand by this and the way that sovereignty claimed by the English feeds into the land ownership or the land law system in Australia itself. What is sovereignty? Sovereignty initially was conceived of both two things. One is the power to govern a territory, and that really represents its contemporary understanding, and the second is the ownership of land. Now these two components of the idea of sovereignty as it was originally understood are going to become very important as we work through the story of land title in Australia. So in the 18th and 19th centuries there were four ways recognised at international law to become sovereign. Now this was an important issue in the so-called Age of Discovery because of course the English would want to lay claim over a territory and be able to exclude the Dutch or the French or the Portuguese or whatever. So all these questions of sovereignty were resolved by international law, which of course in those days was effectively European law. So the four ways recognised to become sovereign were conquest, so you engage in some sort of military campaign and you win a war and you take over the territory. The second was cession, so a country would concede their sovereignty to another to rule over them. The third was settlement, which as a concept depended on there being no existing sovereign entity. So you can contrast this idea with conquest and cession, which assume that there is an existing sovereign entity in the territory. So settlement presupposes that there is no existing sovereign. And finally there's annexation, which is another form of, I guess, political taking over of a territory accompanied by use of force. Now, importantly, underpinning all of this is the concept of whether or not a territory was already occupied or was already under sovereign rule. And the presupposition of settlement was accompanied by the idea of terra nullius, which literally means land belonging to no one. Now this, in its extended sense, the idea of terra nullius doesn't necessarily mean that there are literally no people there. In its extended sense, what it means is that a place has not been settled by anyone else. And if you look at the image up on the screen, this is an image of cleared land marked by fences, punctuated by buildings, and this is really what the English or the Europeans had in mind when they thought about land being inhabited or already settled. So this contrasts greatly with what they saw when they came to Australia. Let's think then about the meaning of uninhabited country and whether there was a recognisable sovereign on the territory. And when the English came to Australia and they saw this apparently deserted place, even though they knew that there were actually people here, what we've got is the potential for the application of the concept in its broadest sense of the idea of land belonging to no one. This idea that the place now called Australia was in fact uninhabited country. So what this meant for the purposes of international law is that the English, because of their conceptualization of what it meant to see inhabited land versus uninhabited land, was that as a question of law, if not of fact, they could deem Australia terra nullius. They could deem Australia land belonging to no one. And this is what underpinned the claim that Australia was settled as opposed to any of the other means of justifying sovereignty. It meant that even though the English had very limited physical control or possession over the territory of Australia, in fact they didn't know how far west it went, they didn't understand the country at all, they could make this claim of terra nullius to justify the idea of settlement and therefore make their claim in international law of being the sovereign nation. So once England could claim Australia at international law, the next question was, what were the consequences of that for the laws that applied within Australia itself, including what property laws and the question of what rules of ownership of land would apply. And what we see here is the collision of two systems of landholding. So on the one hand you have customary ownership of land, the existing framework for possession or control, or in the Anglo-Australian system, property over land. So that existed under its own norms and rules. And there was a fundamental clash between this system and the feudal doctrine of tenure, which is the particular rules and ideas of land ownership and control over land imported by English law. Now, how do we know that English law applied in Australia and what even happened to the existing customary law? So let's just work through these issues in the next couple of slides. English law reflected international law. So while at international law we had this concept of uninhabited country. So remember back to that image of the bucolic farmland and the idea of settlement and the idea of what it meant to be inhabited, contrasted with what the English saw in Australia. We've got this idea of uninhabited country, and it was represented within the common law itself. So this wasn't a question of international law, but there was an equivalent doctrine in English law itself, which is referred to as desert and uncultivated. And this was effectively an equivalent of the idea of terra nullius. So in answering the question, what property law applied, the English law looked to the mode of acquisition of land. So for example, land that had been conquered would retain the existing so-called native law, subject to any changes by the conqueror. So you could see it was really important to, if land had been conquered, English law didn't apply, the existing law continued to apply until it was changed. Land that had been ceded retained native law, subject to any changes by the sovereign. Okay, so you've got a similar sort of situation. But let's contrast land that was deemed to be desert and uncultivated and therefore settled. In these instances, English law applied, subject to any needs particular to the colony itself. So the consequences of declaring that Australia was terra nullius, that it was desert and uncultivated, that it was therefore settled, meant that English land law was deemed to apply in Australia. This effectively cut out any opportunity for the existing peoples, Aboriginal and Torres Strait Islander Australians, to claim that their systems of law took precedence. So let's have a look at what was that English law. English property law was underpinned by the doctrine of tenure, and the doctrine of tenure, which continues to apply, was established in feudal times, and it is not only a system of ownership of land, it's a political system, it's a system of relationships, it's a social ordering, it does a whole lot of things. But let's have a look really in its property owning sense. Pursuant to the doctrine of tenure, the king is literally deemed to own all the land. The king is known as Lord Paramount of the land. And the only possibility for private land ownership is via a grant of land from the king. So what you can see there is that the effect of importing the doctrine of tenure into Australia is that the king was deemed to own all of the land in Australia. So let's use a bit of logic here. If the doctrine of tenure applies, and if the king literally owns all the land as a consequence of the doctrine of tenure, and further, if the only type of possible title is via a grant from the king, then I ask you as a question of logic whether this system of land title can possibly recognise a pre-existing land ownership. So let's see the answer to this question, and what is illustrated in the diagram that you see now is that the effect of the doctrine of tenure is that it locked customary tenures completely outside of of Anglo-Australian land law. There was no possibility for contemplating or incorporating customary tenures into the system of landholding in Australia. Land was Crown land. All of the land was Crown land. Some of it had not yet been the subject of a grant, so it wasn't owned by, say, a private citizen, but some of it had already been granted by the Crown, and once it's granted by the Crown it becomes freehold land, but the Crown still owns the underlying title. There was a seismic shift, however, in the decision of Mabo and the state of Queensland. So let's have a look at the impact of the decision in Mabo on the structure of Anglo-Australian land law. The claim was brought by a number of traditional owners from the Murray Islands in the Torres Strait, so to the north of Queensland. And what you'll see on the screen here is from the National Library of Australia archives. It's a drawing made by Eddie Mabo, the lead applicant in this decision. And this was drawn just on a piece of paper from memory, which showed the traditional titles that he knew from his island in the Torres Strait. And the basis of his claim was that he objected to the state of Queensland imposing its own claims on the Torres Strait Islands. He said, you can't make these claims on the Torres Strait Islands because we're the owners of the land. It doesn't make sense to me that you would make these claims because we have always been the owner of these lands, and we know who owns individual parcels, we know where they come from, and this is all determined according to our laws and customs, and it does not make sense to me that the state of Queensland would be able to make some sort of a claim. And so he and his colleagues brought this action to challenge the claims made by the state of Queensland over their land. They faced quite a significant challenge, however. So let's have a look at those. Let's understand what the challenge were. One of the potential bases for overturning the state's claim to land was to argue that terra nullius did not apply, because the land, of course, was not uninhabited. It was well inhabited, and it was inhabited according to a system of laws that was well known to the existing peoples. The problem with overturning terra nullius was that because it is a question of international law, the effect of overturning terra nullius would be to overturn sovereignty. So once a court says terra nullius is gone, the English are no longer sovereign, all of a sudden it actually invalidates the entire governmental structure of the nation. So courts have very consistently declared that it is beyond their jurisdiction to challenge the sovereignty of the existing nation. Of course, the courts are part of that sovereign system, and they derive their own authority because of that sovereignty. So it was not an option to argue that terra nullius had been overturned. The second option, I guess, was to reject this idea of settlement, to say that in fact the land was inhabited. It was not uninhabited land, and therefore you did not settle the land. This was a myth. That there was some other basis on which the English claimed their sovereignty, but also importantly some other basis on which the legal system was either imported or that there should be recognition of the underlying legal system. Now the problem with this, to reject settlement as a myth, is that there would then be no basis for the English legal system. And what the court recognised in Mabo, that it's too late in the day to overturn these ideas because we would break the skeleton of our system of land law. The problem with rejecting the settlement concept as a myth is that all the people who currently held title to land would lose their interest in land and chaos would ensue. So they needed an argument that would surmount these two quite fundamental problems. So let's have a look at how Mabo and his fellow applicants dealt with this problem, or the way that the court interpreted dealing with this problem. So, in the first place, the court confirmed sovereignty. It's beyond the jurisdiction of the court to overturn any claims of sovereignty by the English in Australia. The second confirmation, I guess, is that of terra nullius. It still applies. It's an international law concept, and we cannot overturn an international law concept. It is outside our jurisdiction. But the option did exist to update the common law, and this is how they did it. The court found that Australia was settled but occupied, so they effectively created a new category, and this would have implications for the way in which the law itself was received or interpreted. So as a consequence of Australia being settled but occupied, the court interpreted the Crown rights upon settlement to be split. It split the idea of sovereignty from the idea of land ownership. It identified that sovereignty, the right to govern over a territory, was quite different from the ownership of land. And this resulted in a new conceptualization of the doctrine of tenure. It resulted in an Australian doctrine of tenure, which supports the capacity for the existence of an alternative type of title, one that's called native title. So let's see how this is done. The way that the court interpreted the effect of being a settled but occupied nation is that the land law that was received divorced sovereignty from ownership. So the court said that as a consequence of sovereignty, the English secured what's known as radical title. This is a type of title that belongs to the Crown. It includes the power to grant interests in land. However, this is not the same as full beneficial title. The court said that upon settlement, the Crown obtained radical title, but at that point, the traditional owners, the existing occupants of Australia, held full beneficial title. So the full beneficial title belonged to traditional owners. However, it can easily be extinguished. The reason it can be extinguished is that radical title and the powers of sovereignty authorize the Crown to do that. So it is a lesser title, it's a fragile title, but importantly, it does exist and continues to exist until and unless it has been extinguished by the Crown itself. So once native title is extinguished, at that point, the doctrine of tenure kicks in. The Crown has full title, and all of the other aspects of the doctrine of tenure will come into play. To establish native title, because indeed, as we'll see, the onus is on the claimants, the traditional owners, to establish that they hold native title requires, in very broad terms, two components. One is an ongoing connection with land in accordance with the norms, the laws and the customs that were in existence at the date of English settlement. And the second requirement is that it has not been extinguished by the operation of Crown power. What's really important to understand as a consequence of the decision in Mabo is that a grant of fee simple, which invokes the doctrine of tenure, is fundamentally incompatible with native title, that this evinces a clear and plain intention by the Crown to extinguish native title. And for this reason, the decision in Mabo was never a threat to any freehold title that had been granted already at that date in Australia. Since Mabo, a number of key events have occurred. So we had this fundamental shift in the entire understanding of the way in which the doctrine of tenure operated in Australia. And it was followed by the Native Title Act, which provided a statutory basis upon which traditional owners could make claims for a determination of native title over their traditional lands. There were subsequently amendments which to the Native Title Act, which narrowed the scope of native title. Quite a well-known decision in Yorta Yorta in the early 2000s further narrowed the conceptualisation of the basis of traditional owner claims to native title. And what we've seen as the general trajectory of native title jurisprudence since the decision of Mabo has been what I'd probably consider to be a chipping away or an erosion of the foundation of native title and the way that it is understood by the Anglo-Australian legal system. So especially in the early days, a number of key decisions were made in relation to native title. It was challenged left, right and centre. So we'll just quickly run through some of the challenges that were made to native title. So the first question was asked in the decision of Western Australia and the Commonwealth: is it even constitutional? Is it possible for a federal claim, for example, or a claim, the claim in terms of state land, to be overridden by some sort of universally applicable law? And the court said, yes, it is constitutional. West Australia and the Commonwealth asked whether the states can overrule native title, and there was an attempt made to do that, and the court said, no, you can't overrule native title. What about, said Western Australia and the Commonwealth, an implied extinguishment through the fact of the state continuing to exercise its sovereign rights? Has there been an implied extinguishment? And the court said no. You need a clear and plain intention to extinguish native title through Parliament or through executive order, and only that will be sufficient. You can't have any sort of implied extinguishment. In Fajo, the court was asked whether native title can revive. So once land has been granted, if it then reverts to Crown land, is it possible that native title will spring up again? The court said no. Once it's gone forever. It cannot be revived. The very well-known decision in Wick asked whether a grant of a pastoral lease would change the underlying title. So was it possible for one type of state grant, a pastoral lease, to coexist with underlying beneficial interest in land? And the court said in this case, pastoral leases that were granted as a consequence of a particular statute could certainly exist or coexist with native title rights. And it was this decision in Wick that prompted amendments to the Native Title Act to read down the scope of native title. In the Yorta Yorta decision, there was an issue of connection, the question of connection, and in this case the court found that while the applicants, the traditional owners, had been successful in reviving their culture, the fact or the reality of dispossession, the reality of removal from lands over years, meant that they hadn't had that continuous connection with land that was required to demonstrate native title. So that's another example of the diminishing scope, I think, of the rights of traditional owners. So just a couple of maps here to illustrate the extent of native title in Australia, and this is current as at 31 December 2016. Here's a register of native title claims. So the blue parts on this map are the claims that are currently in existence as registered by the National Native Title Tribunal. So if you have a look at the location of those claims, you'll see that by and large they are in parts of Australia that tend to be less intensively built up or settled with metropolitan cities and that sort of thing, probably with the exception over in Perth and around there in the southwest, which is the subject of the Noongar claim, which is presently under negotiation with the West Australian government. In the next map, what we see are the determinations. So the areas shown here are areas that have already been litigated and that have been determined as to whether native title exists or doesn't exist. So fairly significant areas in one sense, I guess, but not all have been successful. And again, you'll note that they tend to be outside existing metropolitan areas. So just a quick overview of what we have traversed so far. This idea of terra nullius, which supported the British claims to sovereignty. It's a question of international law, and it affirms that England has the power to rule over the territory. The common law question of what laws applied was enforced through the doctrine of desert and uncultivated, and this permitted the reception of English law and the doctrine of tenure into Australia. We saw that the doctrine of tenure does not permit any type of ownership of land or system of ownership of land that is outside the grant of the Crown, and that in fact all land vests in the Crown. The land rights phase and the declaration in Mabo resulted in a fundamental change to the doctrine of tenure. It divorced sovereignty from ownership of land and confirmed that the Crown only received a radical title at settlement. It found that because Australia was settled but occupied, that the full beneficial title to land remained vested in traditional owners. And of course, since Mabo, we've seen the enactment of the Native Title Act and the slow devolution of the scope of native title itself. And just one last reflection, and this is a statement by the Northern Land Council Chief Executive about the Ord Valley sugar industry development within the last couple of years. He said if we could move away as a nation from treating Aboriginal people as the final hurdle in a development consent process to placing them up front, then perhaps we might get somewhere in Northern Australia. And that's where we'll leave this presentation to cause you to think a little bit about the orientation of our understanding of interests in land and how that plays out in the greater scheme of things.